Let's take a look at electronic communication from an employment law perspective. Computers and other electronic information processing and communication devices are ubiquitous in the workplace and elsewhere. Most employees spend a good part of their workday and often their non work time as well, tethered to electronic communications and other information processing devices. The reliance on electronic communication devices opens new avenues for the monitoring and surveillance of employees and poses profound privacy issues. The Electronic Communications Privacy Act is not exclusively an employment law, but it has been used to challenge employer intrusions of privacy of electronic communication. Under the ECPA, employers are prohibited from intentionally intercepting wire, oral, or electronic communications and from disclosing such information. The unauthorized accessing of stored electronic communications is also prohibited. The distinction between intercepting electronic communication and accessing stored communications has proved troublesome to apply to communications such as email and internet sites. Courts have generally held that the stricter penalties associated with interception apply only when a communication is obtained at the same time it was sent. There is some notable exception to the ECPA's general requirements. Interceptions are legal if prior consent to them was granted. Providers of wire or electronic communication services are exempted from the law's requirements if it's necessary to render service or to protect the rights of property. In the context of telephone conversations, employers can use additional extensions on business phones to monitor business calls for service quality or other business purposes, but cannot listen in on personal calls. State laws are sometimes more restrictive, including requiring notification to all parties that calls are subject to monitoring. Personal calls can be monitored only to the degree needed to determine if they are indeed personal. Thus, an employer violated the ECPA by intercepting, tape recording, and listening to all of its employees' personal calls. Under the stored communications provisions of the ECPA, only the provider of electronic communication service on which the message is stored and users of that service can authorize the accessing of stored communication. Overall, employees are well advised to not assume that their emails and other electronic communications will not be read by their employers, particularly when the employers are the providers of the communication system. The U.S. Supreme Court has been cautious about expanding its recognition of privacy in electronic communication. While criminal cases are different from cases involving public employees, judicial appreciation of the need for privacy in electronic communications seems to be growing.